Today I am going to explain reasonable accommodations for disabled employees and what your rights are in the workplace. And we're starting right now. Hello, welcome to my channel. My name is Brandon Ortiz. I'm an employment lawyer in Burbank, California. Today I'm going to explain reasonable accommodations in the workplace. But before we begin, let me just remind you that this video is not legal advice. If you have a specific situation that you need help with, you should call a lawyer. If you're in California, you can call me. My number is 888-376-7849, or you can click on the link down below. But without further ado, here we go. Reasonable accommodations is the area of employment law that I see employers screw up by far the most. By far, it's not even close. And the reason for that is that it's a complicated area of law. There are a lot of moving parts. It's not always black and white. And there's a lot of overlap with other areas of law. The Americans with Disabilities Act, it overlaps with the Family and Medical Leave Act because you can have leaves of absence to recover from injuries, and that overlaps with the ADA. It can overlap with workers' compensation. In fact, it's extremely common for somebody to have a workers' compensation case and then also end up having a disability discrimination case when they're trying to return from work. So this is a very complicated area, and I'm going to just walk you through the basics. So if you're watching this at home, you may be asking yourself, well, okay, Brandon, what is a disability? And that's an excellent question. Let me begin by telling you what a disability is not. When you're approaching the Americans with Disabilities Act, and when you're approaching the California Fair Employment and Housing Act, which is the California version of the ADA, you set aside definitions of disability that you might see for Social Security, for workers' compensation, for state disability insurance. You set those aside because California and federal law for disabilities in the workplace, it has its own standard. And that is, under California law, it's whether you have a physical or mental condition that limits a major life activity. Under federal law, it's a little bit higher. It's, do you have a physical or mental condition that substantially limits a major life activity? The difference between California and federal law is under federal law, it has to substantially limit. Under California law, it only has to limit. And the law with the most protection is the law that is going to apply in California. So if you're a worker in California, you only have to show that it limits a major life activity. And all that means is that it makes it more difficult for you to achieve that life activity than if you did not have the condition. So some examples of disabilities would be back injuries that limit the type of work you can do. If you have a wrist injury and it places limits on how much you can lift, how often you can lift, that would be a disability. High blood pressure could be a disability. You can have pregnancy-related disabilities. If you have panic attacks and that causes heart palpitations, that leaves you temporarily unable to do your work, that can be a disability. Clinical depression, if that leaves you unable to do a major life activity, that can also be a disability. Now, the California law does contain some exceptions. There are a few things that under California law are exempt from the requirement to reasonably accommodate. If you have a sexual behavior disorder, that does not have to be accommodated. If compulsive gambling, kleptomania, pyromania, these things are literally in the law. Another one is psychoactive substance abuse disorders from unlawful use of controlled substances. That's something that does not have to be accommodated. And I think we could see why for some of these things, especially kleptomania, pyromania, why the law would not require reasonable accommodations for that. So what is a reasonable accommodation? A reasonable accommodation is an exception or a modification or a change to the employer's normal practices that will enable the employee to perform the essential functions of the job. A reasonable accommodation, by definition, is an exception for a disabled employee. And why does the law do that? It's because we want disabled persons to be able to have an equal opportunity to work, just like everybody else. Congress wanted that when it passed the Americans with Disabilities Act, and the California legislature wanted that. And that's something that really trips up a lot of employers, because they'll say, well, we're not discriminating against disabled people. We're treating them just the same as everybody else. But disability discrimination is completely unique and completely different from, say, race discrimination or other areas of discrimination, because the law has an affirmative duty to reasonably accommodate. A number of years ago, there used to be a lot of litigation over no-fault attendance policies. Under a no-fault attendance policy, you get a certain number of absences, say 3 or 5, and that's all you get. And if you go a day over, you're fired, and it doesn't matter what the reason is. And courts uniformly held all over the country that those policies are illegal because they are a refusal to accommodate. The employer has to reasonably accommodate a disabled employee so they can do the essential functions of the job. Now, what are some examples of reasonable accommodations? It can be special equipment. It could be a ramp for a wheelchair could be an example. If a person has poor eyesight, it could be software that reads what's on the screen. If they have wrist issues, wrist problems, it could be dictation software. It can also be job restructuring. It can be reassigning job duties. It can be adjusting somebody's schedule. For example, adjusting a schedule so that the person can go to the doctor. If the person needs to take a leave of absence so that they can recuperate and recover, a reasonable accommodation could be a leave of absence. Providing assistive animals, even emotional support dogs, allowing them into the workplace. That can be a reasonable accommodation. Allowing an employee to work from home. Those are all reasonable accommodations. There is an important limitation on the duty to reasonably accommodate, and that is that the employer does not have to modify or change an essential function of the job. The employer does have to modify, change, or eliminate or redistribute a marginal function, but not an essential function. And a lot of these cases boil down to whether the job duty in question is an essential function. An essential function is the reason the job exists. So let's use as an example a bus driver. What does the position of bus driver exist for? It exists to drive the bus. Now, the bus driver may have other duties. Bus driver might have to fill out reports, but that's not really what the job exists for. So let's use a hypothetical example to sort of illustrate this. Let's say that you are a bus driver and unfortunately you get into a freak accident and you lose your eyesight. Does the employer have to reasonably accommodate you? Well, is blindness or legal blindness something that can be accommodated for a bus driver? Well, you have to be able to drive to be a bus driver. And if you do not have eyesight, you can't drive. You can't get a driver's license. Does the employer have to make an exception and allow you to drive anyways? No, because you cannot perform the essential functions. Now, the employer might have to reassign you to a vacant position if you're qualified for it. So if there's another position that's open that you could perform, let's say there is a secretarial job or some sort of administrative job that you could still do even with your condition, then the employer has to give you priority over any other applicant and has to give you that job. Can't make you compete for it with people off the street. But the employer doesn't have to create a job for you. So if there's one that's vacant, that's already open, they have to give it to you. If there are no vacancies or there are no vacant jobs which you are qualified for, then they don't have to do that. They don't have to give you a promotion, for example. So if the CEO job is available, they don't have to promote you to CEO to comply with the law. But if there is another position which you are qualified for and you have the experience for it, they do have to offer you that. Now, continuing with the example of a bus driver, let's change the fact pattern a little bit. And let's say that you have an allergy to ammonia. And part of your job is to clean the bus after the end of the shift, right? And then let's assume that there are other people in the workplace who could clean the job. So can that employee be reasonably accommodated? I would submit that the answer is yes. I would submit that using ammonia to clean the bus is not an essential function of the job. You can use other chemicals or other cleaners that the person is not allergic to that would be just as effective to clean the bus. You can also have somebody else clean the bus, because at the end of the day, cleaning the bus is probably not the reason that the position of bus driver exists. It exists to drive the bus. And the person wasn't hired because of their ability to clean the bus. They were hired because of their ability to drive the bus. So there's a variety of reasonable accommodations that could be given to an employee in that circumstance. There are a couple of exceptions to the duty to reasonably accommodate, and one of those is when the reasonable accommodation would be dangerous to the health and safety of others. Now, important thing to note is that this is an affirmative defense. What that means is that the boss, the employer, has the burden of proving this. The employee does not have to prove that there's a safe accommodation. It's the opposite. The employer has to prove that the reasonable accommodation would be dangerous. And the factors that the things that they have to prove, the elements is what we call them, is that it's an essential job duty. There is no reasonable accommodation that would allow the person to perform the job without endangering the health or safety of others, and that performing this particular job duty would present an immediate and substantial degree of risk to others. In practice, this exception is pretty hard for employers to establish. Now, the example we were using earlier of accommodating a blind person in the position of bus driver, I would submit that an employer could probably establish that. But for most jobs, it's very hard for the employer to prove that accommodating this employee, letting this employee stay in their job, that's going to create an immediate and substantial degree of risk. Most of the time, the employer is not going to be able to establish this defense. The most common exception that employers argue is undue hardship. Undue hardship is an affirmative defense. The employer has the burden of proof, and the employer must prove that the reasonable accommodation in question is significantly difficult or significantly expensive. The jury will look at a number of factors for that. The first is the nature and cost of the accommodation. The next is the defendant's ability to pay for the accommodation. And that's something that a lot of employers conveniently ignore in disability discrimination cases. If you're going to argue that the accommodation is unaffordable and you can't pay for it, then you got to open your books and you got to prove that. And most employers don't want to do that. And that's where a lot of fighting ends up taking place, is the plaintiff wanting to see the defendant's books to see if the accommodation in question is truly as unduly harsh as the employer is claiming. The next factor that the jury considers is the type of operations conducted at the facility, the impact on the operations of the facility, the number of employees, and the relationship of the employees' duties to one another, and the number, type, and location of the defendant's facilities, and the administrative and financial relationship of the facilities to one another. As you can imagine, this defense has more teeth when it's a smaller mom and pop business. It's much easier for a mom and pop business to argue that the accommodation in question, it's too expensive, it'll make us go bankrupt, we would have to take out loans, our business is not even profitable. It's a little bit easier for a smaller business to establish this defense. If it's a big business, if it's a multi-billion-dollar national corporation, and it's trying to argue that, installing handrails for $2,000, that's somehow an undue hardship, they're not going to get anywhere with that. So, generally speaking, it is much tougher for a big, well-financed, well-capitalized business to assert this defense. Thank you for watching the video. I hope it was helpful. Reasonable accommodations, I think it's by far the most complicated area of employment law, and I gave you just a very high-level overview of it. I mean, we really barely touched the surface of this. It's a complicated area, and if you are trying to get a reasonable accommodation, or if you're being denied a reasonable accommodation, I strongly encourage you to contact a lawyer. It's very easy for the employee to screw up this process. And I see it happen all the time where employees refuse to cooperate in what is called the interactive process, and then they squander what could have been a good case. If you're not able to find a lawyer to help you, then I strongly encourage you to do your own research. I'm actually going to leave down below some links to EEOC guidance. That's the Equal Employment Opportunity Commission. They publish a lot of guidance on the subject of reasonable accommodations and the Americans with Disabilities Act. These are excellent resources, and they're very detailed, and they go through hypothetical examples and fact patterns to explain it, and they're really good. And the odds are that there's a good chance that there's already EEOC guidance on the type of disability or the type of accommodation that you're seeking. So please, I cannot stress enough, you have to be very careful in the way you approach requesting reasonable accommodation to preserve your rights under the law. So please speak to a lawyer, and if you can't find a lawyer, please do your own homework. If you're in California, you can reach me at 888-37-ORTIZ. 888-37-67849. Thank you and stay safe.